Welcome to Washington Arbitration Week 2021, second edition. And this is our last panel of Washington Arbitration Week. And I would like to basically share with you that this panel has an incredible lineup of experts and our moderator who will present each one of the panelists. The only comment that I will give is that the name of this panel is called High Political Risk in Investment Arbitration, the Case Study of Venezuela. And given that that this particular case study has incredible experts both in the law and also knowledgeable experts concerning geopolitics, as well as international arbitration, but also with respect to damages and assessment of political risk and funding from one particular nationality, which is Venezuela. We are very proud to present a full panel of Venezuelans here. Some of them dual nationals, some of them not, etc. But it's an incredible panel, and I particularly feel very proud as a Colombian to have a fully on panel of Venezuelan in this Washington Arbitration closure event. Before giving the floor to Eduardo Mathison, I would like to share with you that this full program was put together by an incredible editorial team, which also includes Eduardo Mathison, but also includes various individuals who I would like to give great credit, including Maria Lucia Casas, who I believe you know from Extrategy, Munia El-Harti Alonso, also from Extrategy, Daniela Janu from Georgetown University, Ian Laird, my co-founder from Crowell and Mooring, Anaïs Leray from Extrategy as well, Eduardo Mathison, who I have already mentioned, Maria Susana Namen from Extrategy, myself, Ashley Rivera from Crowell and Mooring, and Ana Milena Vives. In addition to that, I would like to give enormous thanks to our advisory committee, including Met Kinnear, ICSID Secretary General, Borzu Sabahi from Curtis, Chip Rosenberg from King and Spalding, Gaela Gehring Flores from Allen and Overy, Lee Kaplan from Arendt Fox, Maureen Carlson from Sidley Austin, Kelby Valena from Allen and Overy, and Lucinda Lowe from Steptoe and Johnson. Other than that, it has been a great week. We have received several inquiries about the topics, and what we can say is we can try to uphold our promise to do next year also a more expansive hybrid event. This year we had 2 sessions hybrid, and hopefully, if things go well, we'll be able to be both online and in person. The idea would be to have at least 5 sessions in person, and based on the numbers, we strongly believe that we will not kill the online version, because we think that we can reach out to more people by having it online as well. So for instance, yesterday we connected with people in Vienna who were watching the Washington Arbitration Week at 11 o'clock at night there. Damages experts were connecting with us at that time. We connected with people in Oslo, in Norway, in Africa, in India, and we want to keep that going. So with that, I will go on and introduce Eduardo Mathison, who is an international associate at Crowell and Mooring at its International Dispute Resolution Group, and is based here in Washington, D.C. He also works closely with the firm's International Trade Group, and he focuses mainly in international arbitration. He has experience representing clients in international investment, commercial disputes before the ICSID, the ICDR, the ICC, and several other rules, including the ancestral rules. Eduardo also has experience representing foreign and domestic clients in Foreign Sovereign Immunities Act litigation, including victims of terrorism. In his trade practice, he has experience assisting clients in Latin American countries on US economic sanctions, anti-money laundering, laws and regulations, export controls, customs regulatory, and investment-related issues. Also concerning issues on anti-corruption. I can say that he's duly qualified in both in New York and Venezuela, and he's an active member of PRO's and more in Latin American practice. But more than that, Eduardo has been a force in this version of Washington Arbitration Week. He has been very active, providing ideas as to what we should be doing at a Washington Arbitration Week. And he of course, put together with some thoughts from Ian and myself, this panel, which is an incredible panel, hopefully useful for the case in Venezuela, but also useful for other countries that may entail high country risks. And with you, Eduardo, and his fellow panelists. Thank you.
Thank you, Jose Antonio. Can you all hear me? Oh, good. Great. So thank you, Jose Antonio, for the introduction and for your kind words. I also want to congratulate you and Ian and Maria Lucia, Milena, and the rest of the Washington Arbitration Week team for putting together what has been definitely a very successful week. I'm aware of the enormous amount of work that it took to make this possible. So really well done. And of course, I want to thank everyone for joining us today for this interesting panel, yet Friday afternoon panel. So thank you for being there with us. And I am very excited to be here to moderate this panel, as Jose Antonio mentioned, titled High Political Risk in Investment Arbitration, the Case Study of Venezuela. It is a great honor really to be part of this 100% made in Venezuela panel, including myself. And I am joined by an all-star level pool of panelists today. I have with me Jose Ignacio Hernandez. He's a law professor at the Universidad Católica Andrés Bello in Caracas, Venezuela, and a fellow at Harvard Kennedy School and at the Universidad Castilla-La Mancha in Spain. He's also co-author of this book that I have with me on the defense of the rights and interests of Venezuela by the interim government of Juan Guaidó and their international organization. Also a good friend, Marisael Pradia. She is today with us. She's a global disputes associate at Jones Day in Washington, D.C. with extensive experience in investment and commercial arbitration cases. She's also co-founder of the Georgetown International Arbitration Alumni Group. And finally, we have Thomas Norgar. He's managing director and director of Latin American Investment Development at Gramercy. He was also a litigation associate at Debevoise, New York for many years. So as you can see, we have a wonderful panel and all with different backgrounds and perspectives that we'll share with us today. And we have a lot of questions that we want to cover. It's not going to be easy. But before I go there, let me talk quickly about some logistics. First, we're going to leave time for questions at the end. If you have any questions, please put them in the chat and I'll be happy to share them with the panel at the end. And I understand that the conference has also reserved 15 minutes for breakout sessions, for a breakout session at the end, so we can have a more informal discussion. So please stay with us. So I'm just gonna jump right in, and I think Jose Ignacio is gonna laugh out loud based on what I'm gonna try, and immediately I will try to the impossible task of giving you a quick 2-minute recap of what the past couple of years have been in Venezuela and the current situation, particularly in the international disputes world. So I will try my best. And as many as you know, Venezuela is sadly suffering a major humanitarian crisis. And according to many, the worst that this hemisphere has ever seen. In fact, According to the OAS Working Group on the Crisis of Venezuelan Migrants and Refugees in the Americas region, around 5 to 6 million Venezuelans have been forced to flee the country as a result of political turmoil and human rights violations and a collapse of the economy in recent years. And as many of you know as well, in January 2019, over 50 countries, including the US and the UK and Canada, many others, and even international organizations like the OAS and the Inter-American Development Bank, they recognize the Venezuelan legislature, the National Assembly, as the only government institution democratically elected in Venezuela. And even more importantly, they recognize the head of the Venezuelan National Assembly, Juan Guaidó, as the interim president of Venezuela until free elections can be held, which hasn't happened yet. And this is, of course, for obvious reasons, this is a big deal. And because Venezuela was, well, back then and still is involved in dozens of complex arbitrations resulting mainly from a wave of expropriations and other measures that took place during the Hugo Chavez years in 2000s and the early 2010s, which continue under Nicolás Maduro more recently. The recognition of Juan Guaidó as interim president and the issue, just to give you an example, the issue of who should represent Venezuela in these arbitration proceedings, that of course quickly became a question of law. And today, the reality that we have is that if you ask how much does Venezuela owe between arbitral awards and outstanding bonds and loans from countries like Russia and China and others, etc., if you look at Venezuela's external debt, it is estimated to be as much as $140 billion. That's where we are right now. That's a reality today. And so with all of that said, I will stop here. And I will start by asking the person who had to take over and handle about 60 or more of these arbitrations all at the same time. Jose Ignacio, in this context, what can you tell us about the current state of play in Venezuela and the facts on the ground?
Well, first of all, thank you so much for the invitation, for being here. It's quite a pleasure, Jose Antonio Rivas. I appreciate the invitation, and of course, Eduardo, for your wonderful work today, and as well as Marisael and Thomas. Following my advice, the advice that my medical doctor gave me, I am not going to talk about Venezuelan politics. I am going to talk about briefly about what is the current situation of the Venezuelan economy. And to talk about this, we need to be clear about how Venezuelan collapsed. There have been different versions of how Venezuelan collapsed. According to one version, Venezuelan collapsed due to the drop of the oil prices. Another version states that Venezuela collapsed due to sanctions. But the truth is that Venezuelan collapsed as a result of what the economists call extractive economic institutions or predatory policies that destroy the market mechanism, destroy the oil industry, lead to a GDP collapse estimated in 80%, a collapse of imports, and as a result, an ongoing complex humanitarian emergency. In economic terms, it is necessary to look for countries that are facing terrible wars in order to have a comparison of the Venezuelan economic crisis. For example, I say that the GDP collapse is 80%. This is a greater collapse that the Great Depression hit in the United States, a greater collapse than the Spanish crisis during the Civil War. And if we want to compare another country that suffered a GDP collapse of approximately 80% of the economy, we should look into Germany during the Second World War. And of course, this is very interesting because one of the reasons that explain investors' claims is precisely due to the destruction of the market mechanism through expropriation and other similar measures. Not only Venezuelan economy collapsed, but as you said, Eduardo, Venezuela has an external debt that could be estimated in $140 billion. The republic debt could be estimated in $68 billion. The PDVSA debt could be estimated in $72 billion. And following the distinction between financial and non-financial debt, we could estimate that the financial debt is $107 billion, while the non-financial debt is $33 billion. Just to give you an example, an idea, an imagine of these numbers, the estimated values of Venezuelan asset abroad, including Citgo, PDVSA affiliate, everything, the estimated value is about $20 billion. That means that Venezuela is a country with an external debt of $140 billion, an external asset of only $20 billion. This is the dimension of the crisis that we are suffering. To end, we are looking right now in a sort of economic recovery in Venezuela. Some analysts are talking about the China model in Venezuela. But in my opinion, what is happening in Venezuela is that as a consequence of the collapse of the state, the centralized controls collapse, and now the government doesn't have any capability to destroy property rights. And as a result, there has been an increasing informal economy characterized by a de facto dollarization process. But this hasn't do anything with the China model, because the key of the China model was the introduction of market mechanism despite the authoritarian regime ruling China. But in Venezuela, we do not have market mechanism. We do not have inclusive economic institution. On the contrary, Venezuela is in the last rank of rule of law and economic freedom in the world. So simply what we are looking is a de facto process that will not provide the economic recovery that Venezuela needs to address the complex humanitarian emergency and this gigantic economic collapse, again, estimated in 80% of the GDP.
Thank you, Jose Ignacio, and you mentioned so many interesting things coming from. I mean, the gist that I can take is not that just the collapse of the economy, but beyond. I mean, it goes to the state as a whole. And you also mentioned the de facto dollarization process that is happening right now, and the lack of economic freedom as a whole, which I think is a perfect segue to my next question that I have for you, Marisael. Can you tell us what's the current status for foreign investors with arbitral claims against Venezuela?
Absolutely. Good afternoon, everybody. Before I start, just very quickly, thank you to Washington Arbitration Week and to Eduardo. I'm really humbled to be in this panel with all of you, Jose Ignacio, Thomas, and of course, Eduardo, who we go back for so many years. This is really interesting because as a Venezuelan, obviously, I followed this forever. And just hearing Jose Ignacio put it in those terms really, really shocks you still to the core, especially when you think about a country that is as resource rich as Venezuela is, and you look at what the assets abroad are and what the external debt is, and you ask me, what is the status of the foreign investors that have claims that either have succeeded or who are on the pipeline right now, and even the ones that are not still on the pipeline, and daunting, devastating. But I will bring that down a little bit from the more emotional aspect of this conversation to what the statistics that we have seen with respect to what investor state arbitration looks like in Venezuela under the Chavez and Maduro regime. And what we've seen is that in the last 10 to 15 years, and as Jose Ignacio was mentioning, as a result of the expropriatory policies, we have seen at least 50 cases filed for investor state arbitration alone. That does not count commercial arbitration cases that are also, some of them extremely large, into the billions of dollars. Now, of these cases, there is about 16 cases that are still open, pending. There are 3 cases that are in annulment proceedings that are very important cases, large cases that are facing issues of law that are extremely interesting. And I'll discuss those in a little bit. But one of the things that we're seeing, and it gives you what the status and what the thinking of foreign investors in Venezuela that have exited Venezuela is, in 2001, I've only been able to find one case that's been registered against Venezuela. So obviously the expropriatory policies have not stopped necessarily, and not everyone has already brought a claim. But this to me is an indication that investors are discouraged from bringing claims in this environment because precisely the uncertainty with whether they can be enforced, whether there are assets that can be attached and therefore their awards paid in the event that they win. We also have the issues that we see with respect to sanctions, not just in the US, but other places, but obviously more importantly in the US. And we'll talk about those a little bit more, I hope, in the panel. It's a really interesting conversation because it's a double-edged sword. It may in fact be helping Venezuela keep some of its assets until maybe some creative solutions or some restructuring can take place. But in terms of just sort of an introduction from my end with respect to foreign investors, I think obviously there is an aspect of being discouraged at the moment for bringing claims, but I think that is something that needs to be reconsidered, because unless you put yourself in that queue of potential claimants to be able to recoup your investment, you will not be taken into account when actual change happens.
Thank you, Marisael. And this is very interesting. And yes, I would like to touch upon the sanctions aspect. We'll talk about it shortly. But before we go there, I wanted to ask you, Thomas, maybe the obvious, the easy, not necessarily easy question about based on what Jose Ignacio and Marisael mentioned about the total external debt, the number of cases that either are still, I mean, either in the enforcement phase or the annulment proceedings. What's your view on these foreign investors? Are they going to be able to enforce these awards against Venezuela, or basically, in other words, what's your view? Do you think that they're gonna get paid, and by whom? Thomas, I think you're on mute. Can you hear us? Yeah. All right.
Yes, it's sorry about that. It's a very good question, Eduardo, and well, thank you and all of the panelists. Thank you, Jose Antonio, for the invitation. Clearly, you've done a very good job in the context of this Washington Arbitration Week. Before I start answering that question, though, I just want to make a quick note. If and to the extent that this is being recorded or for future purposes, that whatever I say here should be taken, fundamentally as a personal opinion rather than the opinion of the institution that I work for, which is Gramercy Funds Management. It's a well-known asset manager focusing in Latin America, investments and emerging markets, and we do act as third-party funders. So, and obviously, I just wanted to make that note that any opinions are not necessarily the opinions of Gramercy. But having said that, I think that what you're asking, Eduardo, it's the same question, that it's the same issue that all claimants face when they are when they are at the brink of pulling the trigger and launching international proceedings against a sovereign, not necessarily against Venezuela only, but this is kind of like a more conceptual issue, whether I if I win, whether I'm going to be able to collect, and if so, how do we go about collecting? But also it's a question that many claimants face even after winning a case or winning or success or prevailing in arbitration proceedings. I think it's clear by the numbers that there's just simply not enough assets of the government to satisfy all the pending awards, and so that obviously represents a challenge. My personal opinion is that there, and I think the only way to look at this is to create your investment thesis around the fact that there's more, it's more likely than not that there will be some kind of restructuring or reorganization of Venezuela's public debt. At any point in time when this government or a future government decides to refinance its debt. So there's going to have to be very creative ways. People are going to have to put their heads together and create structures that allow for claimants to recuperate part of what they're owed. Be that as whether it is through the issuance of new public debt, returning some of the assets in the process of trying to reactivate local economy, and maybe even providing some cash to investors that are not necessarily prepared to come back, to go back and operate the assets that they were once expropriated of. So, having said that, I think that the way that we see this is more of a macro view, and in a way, it's going to be quite dependent on whether you are associated or working with institutions that can adequately represent you in that restructuring process. So it's a very difficult question to answer, and again, I think the short answer is this is going to have to be negotiated down the road if and when a new government wants to do some sort of refi.
Thank you, Tomas. And yeah, this is very interesting, and based on the comments that you all have shared so far, what I see is that you have this group. I mean, you have basically like three groups, right? So you have award holders. You also have those who have launched their cases, and those groups 1 and 2, they have no choices. You have to keep pushing and try and hope to be in that part of that settlement, that macro settlement that you mentioned, Thomas. And then there's this third group that you will mention, Marisael, and if you want to comment more on that, of those foreign investors who they haven't brought their claims yet, but their investments were either expropriated or severely affected by arbitrary measures, etc. Either, I mean, it could more likely under Maduro, but it could even go back to Chavez. What do you think, Marisael? I mean, about these new investors? I mean, should they still consider international arbitration as an option? And if not, what other options do they have?
Yeah, so I completely agree with Tomas's point with respect to the risk and with respect to the in order to get paid and in order for this to move forward when and if there's a new government, there needs to be a restructuring, and there needs, in my opinion, to be creative solutions as to how that restructuring is conducted. So with respect to investors who have a claim but have not brought that claim yet, to me, it depends. It's a very case-by-case analysis. There are is true. Some investors that maybe say, you know what, I am never going back to Venezuela. I just might no. But Venezuela is an extremely rich, resource-rich country. There is a lot of opportunities. There's a lot of money to be made, and especially once the economy begins to open. So for those investors that had investments in those type of industries, in those type of sectors, I think that the calculus is different, right? Because for me, the calculus is not just about, I mean, for most, those expropriations or the diminution of value of their investment has occurred already several years ago. In terms of accounting, most of them have already written this off in their books. But what is the opportunity that you can have going forward, not so much to recoup only the money that you lost, but to actually be on the ground when the economy begins working and when you can actually make this investment go. Now, it's not as easy as saying that, because it's obviously when there's a transition from a government like this to an open government, there's always issues of corruption and misappropriation and things that happen, right? Because things are in flux and the rule of law is still being developed. But I think even with that, the fact that it is such a resource-rich country where there's so many opportunities in certain industries, I think it behooves a lot of these investors to consider the risk of going in with the arbitration, so that, as I said earlier, they can put themselves in that queue and actually have at some point a seat at the table in that restructuring process.
It's very interesting, and I think I mean you mentioned it, and I think we talk about it in our preparation for the panel, that you still have, even in some cases, investors whose assets that maybe they weren't like formally confiscated or expropriated, and they still have factories, like retail offices. I mean, they still have some presence. I mean, sometimes they even have a structure. Maybe sometimes what they did is that they took over the entity, but I mean that they're still, I mean, that's still, it's pretty recent, and you can still see it all over the country. I don't know if does anyone want to comment on Marisael's thought? Any comments, Jose Ignacio or Tomas?
Well, the one thing, very quick, 2 seconds, that I was going to say is that I really couldn't agree more with what was said. I mean, on the last category of investors, right? The ones that have technically a claim, or what they think is a claim under international law, and they are still, quote unquote, undecided of, whether to launch international arbitration proceedings against Venezuela. It's obviously, it's kind of like a, it's a judgment call. They may have reasons not to initiate proceedings, and those reasons could be very valid. But my personal opinion is that it's going to be significantly more difficult for an investor to recuperate assets or to have a say, have a seat at the table when the restructuring happens, if they don't have a judgment on which they can rely, and on which then they can say, look, I am officially a creditor of the Republic of Venezuela. I don't think it's impossible to recuperate assets without it, but I do think that it's much more difficult to do it without one. And that obviously is going to depend on the particularities and the intricacies of the case and the situation of individuals, perhaps still living in Venezuela, and all sorts of meta legal considerations.
That's very interesting, and yeah, I couldn't agree more with you, Tomas. Jose Ignacio, did you have any comments?
Yeah, I agree with Marisabel y Tomás, particularly from the perspective of how the Venezuelan debt renegotiation could be implemented. The Venezuelan public debt is similar to the Iraq case because, as I explained, it's not only based on traditional financial instrument, but also on unconventional financial titles, as precisely is the case of the non-financial debt and debt resulted from expropriation and other similar measures. Therefore, once the debt renegotiation process starts, it will be necessary as a first step to advance in a debt reconciliation process. Again, similar to the process conducted in Iraq. And the debt reconciliation process will distinguish clearly between two types of claimants. Claimants that have a title with a compensation amount, of course, financial debt, a note, a bond, or claim based on rulings and arbitration awards, and regrettably, claimants that do not have any title with the amount of the compensation owed. In that second category, it will be necessarily as a preliminary condition to enter into the reconciliation process to implement a mechanism, a quasi-judicial one, to adjudicate the dispute and to determine the amount of the compensation that Venezuela owns. Therefore, claimants that have a title, for instance, an arbitration award, will be in practical terms in a better position once the reconciliation process starts. Otherwise, it will be necessary first to determine, again, the compensation. And in that quasi-judicial procedure, it should be recalled that not only the foreign investors will participate, also the domestic investors. And we are talking about the destruction of an economy, and that procedure to adjudicate compensation claims will be a very, very complex one. Therefore, claimants with a title and arbitration award will be, or an arbitration procedure pending decision, will be in practical terms in a much better position.
Thank you, Jose Ignacio. And I want to go back to you, Marisael, on something that you mentioned and your first comment about sanctions. And I don't want to get into the rhetoric of, because there's one view that the collapse of the economy in Venezuela is because of a sanctions program. I don't want to get into that, Jose Ignacio. I think it was very detailed explaining why this happened. And we will know, and this is something that goes even back way before the sanctions program began in Venezuela, but specifically on the OFAC context and their impact on award holders. What we do know today is that you have, the government of Venezuela, quote unquote, on the Maduro regime, under Maduro, PDVSA, most of the top officials, including Nicolas Maduro, they're, if not all, most of them are designated by OFAC. So my question to you is, how do you see, what's the impact today, not on that future restructuring process, but today, what's the impact of the sanctions program especially on these award holders and overall foreign investors that maybe don't want to wait, that they want to get paid today?
Thank you. That's a very complex question, because it's one that, again, is on a case-by-case basis. But before going to the OFAC question, I just wanted to say one last point on the last bit we were talking about. Sure. In the calculus of an investor with a potential claim. Generally, when you are an investor with a potential claim, you think, am I going to want to go back to that country? If so, then I don't want to do an investor-state arbitration, because I'm essentially shutting my door to that country. Interestingly, that is not the case here, right? So that doesn't necessarily go into that calculus, even if there is some sort of government that is combined in some way. The idea, I think, is that if the restructuring occurs, is that negativity or negative connotation to investors that have brought cases against Venezuela will not be the same as in other countries where the economy hasn't collapsed in the way it has collapsed here. With respect to OFAC, so we all know about sanctions, and we all know that under those sanctions, those assets are frozen and they cannot be used to pay for these awards. We also know that companies can apply for general licenses to try to get permission to be able to use those assets. To my knowledge, and I have to do the caveat, I'm not an expert in OFAC or sanctions. So this is just from my research. I understand that the courts so far have said, look, the sanctions are what the sanctions are. So we will honor the award, but you will not get paid until you're not going to get something else from the court that says, if the sanctions are lifted, you will get paid, right? The court simply has said the sanctions are what they are. You will or will not whenever they are lifted. But from another perspective, not necessarily the investor's perspective, I feel it is actually protecting for at least a short period of time Venezuela's assets outside, protecting it pretty much from everybody until there can be a solution. Because as we were talking earlier, if 20 billion of that goes, of the assets that Venezuela has outside, let's say it's 20, let's say it's 30, let's say it's even 50 billion, whatever that number is, it's still not even enough to pay for all the award, for all the debt that is there, right? So at the end, everybody loses if this is paid in this moment without some sort of restructuring. So to me, while sanctions are difficult and they are definitely an obstacle for getting an award paid at this moment, I think in the long term, if there is in fact a restructuring, they could actually be protecting some of those assets at this moment.
Thank you, Marisael. And it's interesting what you mentioned, and just for those who are not familiar with the sanctions program, the U.S. Treasury and OFAC indeed is able to issue licenses. They could be either general licenses that apply to a certain category of, I mean, if your activity is under the scope of that general license, you don't even have the need to report, I mean, that activity unless it involves money, of course, but it also gives the opportunity to investors or any companies dealing with the Maduro regime or any designated individuals or entities to also apply for specific licenses, and those could be granted by the U.S. government for sure. I don't know, Jose Ignacio, Tomas, do you have any comments on the sanctions component?
Well, I mean, very quickly, I did. I mean, I fully agree with what has been said before. Yes, I mean, having a sanctions regime could, in a way, protect creditors, in a similar fashion that to say insolvency proceeding may protect, commercial creditors, right? In a regular insolvency proceeding in the U.S. So I think in that respect, it's positive. Having said that, it does have a huge impact in our business as a third-party funder, because everything needs to be looked at twice and thrice and four times over to make sure that we're not overstepping and we're not doing anything that could be interpreted as violating any of the sanctions. Obviously, it means additional cost for us as a third-party funder, but also it puts a serious hurdle in our ability to be able to say that we are going to contribute or help, or that the client is going to be able to reach a settlement with the sovereign, because effectively that door is closed. You know, it's something that from a business perspective is definitely detrimental. Although, you know, having said that, I do understand all the reasons behind the sanctions, and I couldn't say that I disagree with their implementation.
Jose Ignacio, any thoughts?
Yeah, briefly. As Tomas explained, there are several negative side effects of sanctions. One positive effect was obtained with the interpretation made by OFAC in December 2019, when OFAC concluded that executive orders prohibit any attachment or seizure against properties of the government of Venezuela in the United States, particularly regarding the PDV holding shares owned by PDVSA. And that is the current policy of the United States government that was recently confirmed when OFAC denied a license requested by Crystalex to advance in the breed of attachment. So sanctions are acting as an asset protection measure. This is another similarity with the Venezuelan case and the IRA case. However, it has not been necessary to rely on sanctions protections, because the defenses implemented by the Republic and PDVSA and also Citgo has deferred the most imminent risk. Not even Crystalex and Conoco, that are trying, as we all know, to enforce arbitral awards, that are in the first line, but not even those claimants poses an imminent risk, because the case at the Delaware court still has months ahead until eventually a sale process of PDV holding shares could be conducted. So we need to wait until the end of that process, approximately at the end of 2022, to look if sanctions effectively will prevent creditors to seize Citgo, because until now we only have an interpretation, and again a denial of a license that in any case cannot be implemented because there is still months ahead of the case at the Delaware court.
And Jose Ignacio, let me ask you, changing topic slightly. I know we're getting closer to the Q&A session, but have you seen investors, and anyone feel free to jump in, have you seen any investors trying to find any like more creative ways, alternative to just going after Venezuela public assets?
Yeah, recently several bondholders, one of the cases is Casa Express. They started a claim to seize block properties, but not from the government of Venezuela, but from other persons that have been sanctions due to their involvement in corruption and violation of human rights. This is, by the way, a similar strategy implemented by the victims of the FARC that were able to seize not only block properties of the government of Venezuela, but also block properties of third parties related to the Venezuelan corruption and pervasive kleptocracy. So that is an innovative way. Another innovative way is try to seize assets derived from kleptocracy. Because again, the main problem is that Citgo is, I think that was is not the case, but still is a sort of magnet from creditors, because Venezuela doesn't have much asset abroad, and a very important portion of those assets are protected by the sovereign immunity. And beside of that, assets in the Caribbean and Europe has been seized, attached, or destroyed by Maduro's regime. Basically, the only valuable asset abroad is Citgo. But to be honest, Citgo has already too much problem with creditors in line and its own debt to try to be able to solve all the problems. So for sure, creditors will need to find an innovative way. And this idea, again, trying to attach block properties of third party and event parties, and eventually trying to seize asset resulted from kleptocracy, could be a very innovative way. And in my personal opinion, the probability of successful in those innovative case is higher than the probability to have any success trying to seize Citgo, because between the creditors that are already in first line and sanctions, I do not have too much expectation regarding any Citgo seizure.
We'll see. We'll see. And I think my last question before we open we give the floor to the Zoom audience. But I assume that's something that is in everyone's minds. The reality on today that it's been over 2 years since Juan Guaido was recognized as interim president of Venezuela until free elections can be held. There haven't been any free elections, but the reality on the ground is that the Maduro regime is still remaining as a de facto government of Venezuela. They still control the military and therefore the Venezuelan territory. 2 weeks ago, they show that still Maduro is totally free and able to pick to choose any governor of his convenience. He runs a parallel legislature and has complete control over all branches. And that's where we are today at the end of 2021. But assuming that there will be, there has to be some sort of political or some changes in the political spectrum in the future. How do you, I mean, considering this reality today, how do you envision that those changes, and what role do you think the investors will play there? Could be the restructuring or could be something else. Do any of you have any thoughts on what could happen and what options are left until that happens? I don't know if it was an easy question. Come on. I don't know.
Well, I will take that. I will break the ice. The end of the usurpation was not achieved according to the 2019 plan. That's a fact. And it is necessary to think in another strategy. And this is one of the causes that explain the Mexico negotiations. But at the same time, Maduro has not improved its capability. Maduro is not in a better condition than in 2019, in my opinion. Maduro's regime is in a worse condition due to the increasing lack of legitimacy, not only related to the political crisis, but also with other conditions, such as the investigation opened by the Public Prosecutor Office of the International Criminal Court, and the several indictments against Maduro elites. Therefore, to be honest, neither interim President Guaido nor Maduro can do anything regarding the debt. But both sides are aware that it is necessary to find a solution to stop the Venezuelan economic crisis, particularly regarding the oil sector. And I will say that for the very first time in the Venezuelan contemporary history, there is an increasing political consensus among the necessity to promote private investment in the oil sector. Due to the level of destruction of the oil sector and practical circumstances, because according to several estimations, the capex necessary to reboost the oil industry could be estimated between $100 and $200 billion. And the Venezuelan state, ruling by Maduro, ruling by Guaido, ruling by whatever you want, simply do not have the capacity to invest $200 billion in the oil industry. So the main question is, how can Venezuelan economy be recovered? Maduro tried to follow this informal path of informal institutions, opaque transactions based in this anti-blockade law. He tried to promote private investment investment in the oil industry with this informal agreement. But until market mechanisms are not duly restored in Venezuela, it will be not possible to promote the private investment necessarily, not to a tiny economic recovery of 2-3%. We are not talking about that. If we really want to recover oil production at least to the level of 1999 in the relatively short window that we have as a result of the energetic transition, it will necessarily to dramatically improve the quality of the institutional framework. And for that purpose, it is necessary to restore market mechanism. And a core component, again, a core component to restore market mechanism is to restore property rights that were violated by the predatory policies of Hugo Chavez and Nicolas Maduro, not only in the oil sector, and we have claimants such as Conoco and Exxon, but also in other sectors of the Venezuelan economy, including particularly the food sector. So this is why, in my opinion, foreign investors and generally speaking, private investors, they are in a relatively good position regarding other creditors because they can be compensated as a result of the policies implemented to recover Venezuelan economy. And for instance, I have been working for a while in a mechanism to promote the settlement of claims, investor claims, through public-private agreements that allows those investors to resume control over assets and recover them to boost the Venezuelan economy at the same time that the Venezuelan state pays the compensation owed to them. As you can see, this is a crucial moment, in my opinion, in Venezuela, and this is why the Mexico negotiations, among one of the points of agenda, include precisely right over assets, sanctions, and generally speaking, what to do with the Venezuelan debt as a binding constraint to promote economic growth in Venezuela.
Thank you, Jose Ignacio. And yeah, and you will mention that it's not only foreign investors, and you said at the beginning, it also covers domestic investors, many Venezuelan individuals and entities whose investment have also been affected dramatically, and they haven't had a resource to go to an independent judicial system to obtain compensation. I have one question from the audience. I think, I don't know, Marisael, if you want to comment on this, I'm gonna read it. What is the current role of the interim government of Venezuela in the arbitrations? Is it a respondent or more similar to an amicus? And what are the complications this could bring to the arbitrations and the enforcement of the awards?
That's a great question, and one that is extremely difficult to respond to because it changes depending on what forum you are arguing it. So this is exactly another of the reasons why investors, not so much the ones that are already kind of in it, that have brought investments already, investors in arbitrations already, but those that are thinking of bringing them, this has added a whole layer of difficulty for determining who is respondent, who is the representative of respondent, and who decides who that representative is, right? So in what I have seen, when you're looking at courts making this determination, both in the US and the UK, that tended to rely on the political questions sort of doctrine, not so much in the UK, but the idea that who the representative is a political issue, is not necessarily a judicial issue, and therefore, depending on who the government has recognized in that particular jurisdiction, is who the representative is. But arbitral tribunals are not necessarily doing that, right? Arbitral tribunals are, by and large, deciding this is a question we can take on, and they've taken on that question, and the results of that have been varied, to say the least. And so who the representative is an open question, depending on the case and your tribunal, if you're an investor state arbitration, depending on the history of the case. In one case, the tribunal said, well, we don't, there's all this historical background. We don't want to change what's been happening, and therefore we're going to continue with this particular side as being the representative. In one question that hasn't arisen yet, but is something that I have brought up in our internal conversations that I share with the audience as well, is what would happen in annulment if this is contested or challenged as outside of the jurisdiction of the tribunal to determine who the representative is, right? We know that the tribunal can determine for sure who the parties are, but this is a question that goes beyond just merely a nationality determination, right? This includes a political decision, a political issue.
Jose Ignacio or Tomas, any comments, any thoughts? Tomas, I think you're on mute. I'm not sure if you're, yeah.
So the one thing very briefly that I was going to mention is, I mean, yeah, look, I agree that the question of who is the representative of Venezuela in the context of these international arbitration proceedings is complex. It's a complex one, but it doesn't really. I don't think that it is one that it is up for the claimant to respond or necessarily figure out. In my experience, the position that has been taken, the position that claimants have taken is, I don't care who is the representative. If push comes to shove, I'm going to treat both the procurador in Venezuela and Guaido's procurador equally the same. And I'm not going to be, trying to push one out of the proceedings. I'm going to let the tribunal make that decision, because as a claimant, one thing that you also don't want to do is to give the Republic of Venezuela additional arguments to seek annulment. So you definitely don't want to be in a position where Venezuela could argue that they didn't have due process, for instance. So in a way, it kind of like it's a little bit of a moot question and more of a like an inconvenience for the purposes of the tribunal. I understand and I appreciate that it's very important for the Guaido administration and also for the Maduro administration, but for the purposes of claimant and third-party funders, it's more, it's a little bit irrelevant.
President, do you want to comment, to make a comment on?
Yeah, I briefly want to comment a very interesting case that is Valores Mundiales at ICSID. Before the U.S. courts, the position was absolutely clear, based on the one voice doctrine, and the position was that only the interim government has the right to represent Venezuela. And at some point, claimants even go directly to serve the government of Venezuela through the interim government. But the problem in arbitration was more complex. And in one case, Valores Mundiales, an annulment commission decided that the government of Venezuela was Maduro, not Guaido. In my opinion, that was a wrongful decision because, as Marisael explained, the government recognition is a political question, not a de jure question. And therefore, arbitration tribunals and annulment commissions doesn't have the power or jurisdiction to decide that question. But in any case, in this particular case, Valores Mundiales, the annulment commission decided that only the government of Venezuela should be allowed as representative of Venezuela. Then Maduro abandoned the case, the stay of the award was lifted, and the creditor resume the procedure before the DC court, the Washington DC court, for the enforcement of the award. And only the interim government was able to represent Venezuela, and the defense of the government of Venezuela in that case was, I was excluded from the annulment procedure, and this is a disorder because according to the one voice doctrine, there could be only one government of Venezuela. It doesn't make any sense that you have a government of Venezuela in arbitration awards, in arbitration procedures, and then another government of Venezuela in before the DC courts, the United States court, So that was the only case in which there was a real conflict between or about the representation of the government of Venezuela. Beside of that, in ICSID, the Maduro's regime has the representation of all the cases with only one exception, which is another very interesting case. And that exception is the Conoco case that is currently in an annulment committee. And in that case, and this is mind-blowing to be absolutely honest, the government of Venezuela is represented by two governments. I mean, Maduro through his lawyers and Guaido through his lawyer. That is a unique case. And the reason why the annulment commission take this decision was because they decided that as annulment commission, they had no jurisdiction to decide who the government is, and they decided to preserve the status quo. But what happened is that one of the law firms that were represented Venezuela under the instruction of Maduro's regime decided to follow instruction of the interim government, while the other law firm that was represented the government of Venezuela decided to follow instruction of Maduro's regime. So that is the only case in which the interim government has some level of control. But besides Conoco case, in the rest of cases before ICSID, the representation of Venezuela has been exercised exclusively by Maduro's regime. And as Thomas said, this is why one of the reasons why, for practical reasons for investors, doesn't make any difference. This political problem of who the government of Venezuela is, because before ICSID is clearly the government of Maduro that has the representation of Venezuela.
Thanks, Jose Ignacio. And it sounds like we're running out of time. But before we go to the breakout sessions, do any of you would like to share any final takeaways? We've covered a lot. I'm feeling pretty good about. I thought that we're going to be able to make it through all of the things that we wanted to cover. But do any of you have any final thoughts or takeaways?
On my end, just I hope, Jose Ignacio, that what you're saying about the restructuring and what is happening with respect to investors being able to maybe exert some change, that in fact does happen in the near future, because not just for Venezuelans in general, but just in terms of the economy and foreign investors that are waiting in line to get recovery, it would be a huge, huge deal.
Yes, absolutely. I would like to end with this idea. Venezuela desperately needs private investment. And private investors required, as any other investors, market mechanisms. And this is something that Maduro regime cannot provide. This is why the economic recovery of Venezuela will need to achieve a political agreement to restore market mechanism, restore property rights, and create the proper conditions to promote domestic and foreign investment in Venezuela, because the economic recovery of a country that has lost almost 80% of its GDP will demand high levels of investment. And again, this is something that needs market mechanism and therefore political stability.
Well, with that, I want to thank you again for your time. What it was a very interesting discussion. I really enjoy it, and I hope that we continue this discussion in the future. And I want to thank you again, everyone, for joining us today. And with that, back to you, Jose Antonio.
Thank you so much, Eduardo, and congratulations in the order that I see you, Marisael. It's always a pleasure to to listen to you and the analytical tools that you bring to the table, straight out of our class in investment arbitration at Georgetown. So really good to listen to you, Jose Ignacio. Wonderful to also bring the economic, the macroeconomic perspective in which Venezuela is, and also the more policy-oriented alternatives that may not be easy, but must be there to see a light at the end of the tunnel. So I think that the theme here was country risk, but I think that you have incredibly provided alternatives out of the current situation. They might not be in 6 months, but at the end of the day, the sort of humanitarian and economic crisis cannot be forever. And of course, Eduardo, and thanks also to Thomas. I think that we might have lost him. I don't know whether technical difficulties, but Thomas also brought a very specific and concrete perspective. And I would like to say that this is a very complex issue that involves, as you all put it, a humanitarian crisis. And I really want to commend each one of you, of course, Eduardo for his master moderation here, to bring the analysis to everyone, and also sort of, despite the fact that you must feel the whole situation in your guts, because it's definitely your place of birth, and you still must have many connections to Venezuela. So I am thankful, because it was a topic treated with huge levels of respect, and I can only say thanks. And it may be useful for other case studies regarding international arbitration and high country risks. So Thomas, I was just also commending you, and thank you for being with us.
Thank you. Sorry that I got disconnected very briefly, just a technical problem, but I'm so thankful for the invitation.
No, we're the ones who have to say thank you, because it's not an easy thing to do, to bring the analytical tools that you all brought and share them with the public. I think that we have a big audience, and with that, I would like to give way to our breakout rooms. We would ask you that you remain online, and we're going to send you to the various breakout rooms. Make sure that you hit the accept button, because otherwise you'll stay in the main room. The idea of the breakout rooms is not necessarily to give counsel or advice. Simply, it's a network. It's a network opportunity. Most people want to see the stars, and in this panel, you are the stars. So stay tuned, and stay tuned also for our next Washington Arbitration, which will happen next year in 2022, the day after, the week after Thanksgiving. So it will happen that date. We've been locking with that specific date, and we're locking it in. So have a wonderful day, and enjoy the breakout rooms. Take good care. Bye-bye.
Thanks a lot, Jose Antonio.
Thank you.
Thank you. Bye-bye, everyone.